Welcome to the Hertfordshire Chamber of Commerce's webinar today entitled Business Turnaround and Growth webinar. My name is Mary Sykes and I'm your host for today. It is my pleasure to also welcome specially some of the patrons who are on the call with us today. Longmores Solicitors, of course, who will be presenting, along with the University of Hertfordshire and Barclays Bank. Again, welcome to all of you. We really appreciate your participation and look forward to some active dialogue after our presentations. The event today will be recorded, just to let you know, and we'll share that link with you afterwards, along with, my understanding is, the delegates' names who have registered for today. Please keep your questions, as I say, to the chat function, and we'll get to those afterwards. It's now my pleasure to introduce you to our speakers. First, we have Nat Young. Good morning, Nat.
Morning.
Nat is Senior Solicitor at Longmores, specializing in insolvency and dispute resolution, and he will be taking forward the topic of turnaround. Next, I'd like to welcome Michael Budd. Where's Michael? Good morning, Michael.
Good morning.
Michael is partner and head of company commercial at Longmores, and his topic will be focusing on growth. And next we have Paul Barwick. Good morning, Paul.
Morning.
Paul is a partner at AZETS, and he will be focusing on valuation. Our aim is to complete the webinar by 11:45, but we appreciate this is a really important topic, and many of you may want to, as I say, post questions, but even after the webinar is over, we will share all of Longmores and AZET's details should you have some personal questions and help and guidance that you need. So without any further ado, I will hand over now to Longmores for the first of the presentations, starting with Nat. Thank you.
Yes, good morning, everyone. First of all, I just wanted to introduce what we're speaking about today and why. Obviously, turnaround is a very important subject at the minute. A change of direction is, I think, what all of us have had to go through in the last few months. But in this business context, it means a process where a business has suffered from poor performance and it begins to recover and grow. And that's then the next topic, which is obviously the growth element, and I'll pass over to Michael at that point. And because it's such a huge topic, he'll be focusing in on just some of those options for funding growth, because often that growth will require funding. And then obviously Paul will be dealing with valuations, which are often a very critical part of any restructuring or any as a way to unlock funding for a turnaround or to implement a growth strategy. First of all, my topic is turnaround. So when we talk about turnaround, this is something that can apply whether your business is insolvent, in which case it's quite pressing, or it could be just a relative period of underperformance. And in that case, obviously, that would be a solvent turnaround. It's important to distinguish the two, and I've split them up in my presentation because of a couple of factors. Solvent businesses usually have a bit more time. They have more control over the process because they're not so dependent on other parties and stakeholders. And also the management of a solvent business doing a turnaround doesn't have the same sort of risks. And I talk about that a bit more when I come on to insolvent turnaround later on, so I won't deal with it in much detail at this stage. But talking specifically about solvent turnaround, the first question is, well, do you need to turn around? And obviously, one of the questions would be, have you got the wrong strategy in place for current circumstances, or are you just seeing a temporary period of underperformance? And with COVID, obviously, and lockdowns, that's a big question for some businesses. If you're in something like live events, you might have had an excellent business plan in December last year. You could have gone to your bank, they'd have been thrilled with it. Everything started off nicely in January, and then suddenly, obviously, the rug is pulled from under your feet, and you just can't carry on. But then the question comes, well, are you going to be able to carry on in the same way? Have you still got the right strategy fundamentally? Does it just mean that we have to wait for the end of lockdown? Or do you now need to change your strategy? Do you need a turnaround? And what I would say on that is just one thing. It's obviously business specific. But the one thing I would say is obviously human nature is to point the finger at other people or other circumstances. So very often it's a good idea to assume you do need a turnaround if you're going through a period of poor performance. But it's not necessarily going to be in every case. If you worked out you do need to turn your business round, then the questions are, well, where are you going to turn to? What's that going to look like? What's your new growth strategy going to look like? And then how are you going to implement that? So what are the steps that you need to take to get from where you are now to get to that new direction that you want to position yourself in? And in that respect, you often find that there are a few different obstacles to turnarounds. And one of them is having the wrong turnaround plan. Obviously, if you don't have the right plan, it doesn't matter how you implement it. But more often you have problems implementing. You can see that you need to improve cash flow. You can see that you need to handle different parts of the business differently. But you encounter problems doing that. Sometimes that's personnel problems. It might be resistance to change among your staff or amongst management. It could be, though, something like accrued issues. Maybe if you're facing a substantial piece of litigation because of a risky venture you got into, that's going to affect you going forward. And then you also have the structural issues. So sometimes you find, for example, that you're just too big or you're just too small. And sometimes you find that you've got fixed assets and potentially lending against fixed assets. That means that what you want to achieve by way of a turnaround, actually it isn't possible because you've got these structural issues. So I've just listed there a few kind of options that you might want to consider if you're looking at turning around a business and you are solvent. One is new funding. Sometimes in its own, new funding might be enough. That's the idea, obviously, of bounce back loans. It's the idea that you get a bit of funding to tide you over and then you're bouncing back quickly. You might need external consultants. You might need some help to implement your plan or even devise your plan and work out what you need to do. Sometimes you might need a change of management. And then if you've got those structural problems I was talking about, you might be looking at a sale or a merger, potentially a restructuring. You might want to split operations, maybe sell part of the business, carry on with something more core to your business. And then I've put in there scheme of arrangement. I think that's likely to be of more interest to larger companies, but sometimes when you've got a lot of lending and lenders with different rights, it can be quite difficult to turn around, and you sometimes need to have a scheme of arrangement in place, which is a sort of court supervised way of restructuring your business. So that's solvent turnaround. And then obviously you have the altogether more tricky topic of how to do a turnaround if you're already insolvent. Now, insolvency, you've got to be able to spot insolvency. There are two main measures that are used. It basically means you can't pay your debts, but if you're cash flow insolvent, that means you can't pay your debts as they fall due. You can't pay them now. You've got creditors building up, you're behind with your payments to suppliers, and so on. Balance sheet insolvency, on the other hand, means that your assets, your total assets, are less than your liabilities. So in that case, you might have enough to pay the creditors that you've got now, but you've got a big creditor coming up in 5 years' time, and you've got no assets with which to pay them. Your balance sheet insolvent. And as I explain later, the different methods of doing an insolvent turnaround do vary quite a lot, depending whether you're looking at a cash flow insolvency and a sort of immediate problem with creditors, or whether you're potentially looking at a longer term issue. I mentioned those special problems that you have with insolvent turnarounds, and that's really why you've got these special methods. When people talk about CVAs, administration, so why do you have these special methods? Well, it's because you've got these particular problems. One is simply obtaining finance is difficult because often lenders don't want to touch you because you're already insolvent. Getting buy-in from creditors can be an issue because one creditor might say, well, why should I compromise if nobody else is compromising? or they might all just be trying to get to the front of the queue. You know, they will start court proceedings faster, they might get paid faster, and so on. You've got these ipso facto clauses. That's going to be less of a problem now because of reforms earlier this year. But what that means is essentially clauses in contracts that mean that if you're insolvent, the contract ends up terminating. So you start losing suppliers, you start not being able to carry on your business just because people are refusing to deal with you. And then there's the risks to the management. So if you're a director of an insolvent company and you're doing a turnaround, you're looking over your shoulder worrying about, am I going to be blamed later? You know, if I make this decision and take out this new funding, you know, are they then going to argue later I shouldn't have done that, that I'm wrongfully trading or something like that? So those risks to the management make insolvency, insolvent turnaround, a more complicated proposition. So next, talking in more detail about the different methods of insolvency, insolvent turnaround. The first thing is to notice that if your balance sheet insolvent, you have got enough cash for your day-to-day needs, then you don't necessarily need to worry too much about these special methods. It might be if you've got, for example, a particular long-term debts that mean that your balance sheet insolvent, but you are profitable, and you've been trading consistently profitably for a few years. It might be 2 or 3 years of trading. You might return to solvency. There's nothing inherently wrong with carrying on in those circumstances. You do potentially have to worry about a few risks and things like that as a director if you make that decision, but it's not inherently a wrong decision to make. And similarly, if you're cash flow insolvent now, you're going to have fewer options than if you potentially are looking ahead and saying, well, I've got the cash I need as a business now, but maybe in 3 months, I'm going to run out of cash. Obviously, that's one good reason to get cash flow forecasts and to get good management accounts and so on. If you're going to be cash flow insolvent at a future point, it might be possible to do a sort of urgent turnaround before that happens. Just focus on getting in cash, maybe sell some assets, maybe raise some new finance, maybe just informally reach an agreement with creditors and suppliers to sort of ease the terms. And that might be enough, and then you can avoid cash flow insolvency and carry on like a solvent turnaround. The other option you have, if you're not being pressed too heavily by your creditors at this stage, but you're potentially in a position where you know the crunch is coming, is a CVA. So in that situation, you basically reach an agreement with your creditors. And as long as enough of your creditors agree to it, then all your creditors are bound by it. So a CVA is quite a powerful tool to turn around an insolvent business. But as from this year, CVAs don't have any kind of moratorium. So it doesn't stop a creditor, say, presenting a winding up petition against you, or doesn't stop, say, action by a landlord or something like that. So if you're doing a CVA, you do need to have a bit of, if you're doing it on its own as a standalone option, then you need to make sure that you're not under immediate pressure. The other problem you have with potentially carrying on with a CVA arrangement is you do need that buy-in from the majority of your creditors. So it's okay, you've got a couple of holdouts that say, you know, we're never going to agree to this. But if you've got, say, one big creditor, you basically need them on side. Otherwise, you're not going to get that CVA agreed to. If you're cash flow insolvent now in the present, so you just literally don't have enough money to pay the debts as they fall due, then what you need is a moratorium. And a moratorium is basically a sort of legal rule that stops creditors chasing you and stops them presenting winding up petitions and therefore putting you into liquidation before you've finished your turnaround. And moratoriums traditionally are attached to different insolvency turnaround options, particularly attached to an administration. There used to be a moratorium on CVAs. They've now abolished that and replaced it with this new standalone moratorium earlier this year. The standalone moratorium is meant to be a sort of simpler procedure that's suitable for businesses where they just have a temporary crunch, a temporary issue with their creditors. They need 4 to 8 weeks to sort of solve things. but in the end, they don't need any special measures. They don't need a sort of long-term, they don't have a long-term problem. My view is that it's unlikely to be popular. I think it's a bit flawed, the way they've set it up. And I don't think it's going to be popular with insolvency practitioners that are actually going to have to supervise these. But we'll see what happens. Sometimes people look into the scheme and say, well, actually, I think there is a way to make this work. So that's definitely something that might be worth considering. I think the more realistic option, and really the sort of main option, if you're looking at an insolvent turnaround, so you're planning to carry on the business as a going concern in some form, is to look at administration. And administration is very flexible. There's lots of different methods of going through an administration, but I'll just highlight a couple of them. One is to do an administration with a view to reaching a CVA, but getting that moratorium. So effectively you couple the two methods together. The second is what some insolvency practitioners have been offering recently, is a light touch administration, where the administrator steps back and doesn't try and run the business like in a trading administration in the traditional sense, but they let the directors get on with it. There's still that moratorium in place, and then potentially they can do that turnaround by buying time. But I suppose the main and most popular way of using administration is to use administration to ultimately sell the business, and very often sell the business back to management. You might have heard of a pre-pack where that's all arranged in advance, but it doesn't need to be like that. It could be arranged after the event. But either way, the administrator is appointed and you buy the business back from them. And then if you've got inherited problems like massive awards against you in litigation or bad debts and things like that, then you can put those behind you, and you've still got that profitable business going forwards. I've just mentioned a couple of other things on my slide, one being the super scheme. Virgin Atlantic, I think, recently went into one. It's like a scheme, but it's for insolvent businesses. And again, it's really for ones with lots of different classes of creditor, so probably not for SMEs. And then finally, there's liquidation. It's not really a turnaround option. It's more what happens if you don't manage to turn around the business and it's insolvent. But sometimes, it's enough to put the business into liquidation and then potentially buy some assets back and start afresh. So on that gloomy note, probably best to make way for Michael and talk about something more positive and talk about growth.
Thank you, Nat. Good morning to everybody. There's obviously a lot to cover here, so I will be as quick as I can in order to give Paul an opportunity to speak as well. So just looking at the next slide, the overall there are numerous funding options available, and as we've listed them there for convenience, but the one we're really going to concentrate on is in relation to the next slide, really, and that's from venture capitalists and angel investors, and what do they look for, and we're going to consider this really from the company's perspective. So one of the key things that a company will need to do before it starts looking for any investment is to ensure that it has gone through a proper planning process. It's got itself investment ready. So in order to do that, it needs to make sure that all of its documentation, record keeping, etc., is in order, because what it doesn't want to do is have to answer the numerous questions that the investor will have whilst also trying to run the business. So typically the investor is going to ask questions about the business ownership, intellectual property rights, its customers and suppliers, directors, employees, financial records, IT system, management information, etc. So in order to do that, because of the principle of caveat emptor, let the investor beware, the buyer will ask numerous questions through a due diligence process, both in questionnaires and also wanting to look at relevant information that is revealed from the answers to the questions. One of the key things, and that a lot of companies in their desperation to get the investment in forgets about, is that obviously the information that's being handed over is confidential. So wanting to always ensure there is a confidentiality agreement in place before any information is handed over. And also that confidentiality agreement needs to ensure that it covers information, discussions that have been had between the parties prior to the date of the confidentiality agreement is entered into. So on to the next slide, we talk about sort of the basic structure of the investment documentation, really the investment agreements. One of the questions that we will get asked typically from companies is whether or not any of the money that the investor proposes to invest can be diverted to the shareholders. And clearly, yes, that is a possibility. And so shareholders can sort of make effectively a partial exit. But like with all of these things, when money is going to shareholders, I need to make sure they get tax advice in relation to that. The key documentation is the investment agreement. And in consequence of the investors' due diligence process and the answer to inquiries, etc., and because of the caveat emptor principle, the protection that the investor will get is through warranties. So warranties are statements of truth as to the condition and state of the business which the investor is proposing to invest. So they normally are quite extensive. And one of the key questions is, well, who is going to give those warranties? Well, normally it's going to be the company, but it may well be that certain senior majority shareholders, for example, senior management people will also be expected to give warranties, even though they may not be receiving any money from the investment. So one of the key things in relation to that is to ensure that there are limitations around the scope of liability or the extent of the liability that the warrantors are going to suffer. So there should be financial caps and various hurdles and obstacles for the investor to go over before it can make a breach of warranty claim. And one of the obvious questions in relation to that is if, for example, there are warranties concerning, let's say, the company not being involved in any litigation. If that is not the case, then how do the warrantors avoid liability for that? Well, normally they will do that through a form of a disclosure letter, which sets out the extent to which the warranty is untrue. So in the litigation example, it will set out to what the extent of the company's involvement in any litigation and its status, and then that will relieve the warrantors of any liabilities in relation to that. Just turning to the next slide. One of the way that investments are structured, there are two aspects to it overall, and broadly that relates to the transactional side, which is also very relevant to a share or asset sale and purchase, which is the process I've just described. And there is the ongoing relationship, so the shareholder relations aspect with the investor. So the investor they will be looking overall to ensure that there is some control in how the company operates. Obviously, it wants to protect its investment. So one of the things it will do is appoint an investor director or perhaps an observer if it doesn't want to appoint a director. And there may be some requirement for the company to make sort of monthly payments, for example, to the investor director. And the spending liabilities that the company is going to undertake. So the next slide, that is really dealt with by way of investor consent. So it would be a list of matters that the investor will require its prior consent for the company to undertake. So that may well be hiring people on certain salaries, or acquiring other businesses, or selling parts of its existing business. It would also expect certain senior people to enter into restrictive covenants. There will be business plans required to be produced, and there will be restrictions regarding, in all likelihood, depending on the percentage of shareholding, issues of shares to new shareholders, although some exceptions should typically be made for shares that are proposed to be issued to employees. And there may be some good and bad leaver provisions which apply to some of the senior people, so to prevent them from leaving, or the senior shareholders from leaving within a certain period of time. And it'll also be restrictions around the transfer of shares as well. As I say, I've just touched on some of the very key issues there, and conscious of time, I will pass over to Paul.
Thank you, Michael. Well, good morning, everyone. In the next 5 minutes or so, I'm just going to touch on the reasons for having a valuation, walk you through a valuation at a high level, describe some of the valuation techniques often used, and then again finally touch on the impact that COVID's having on some of the valuations at the moment. So reasons for a valuation. Why would someone have a valuation? Well, at the moment, matrimonial purposes, I think lockdown has been not so kind to many husband and wives out there, and seeing a lot of matrimonial disputes whereby the assets need to be distributed between the two parties for funding reasons, obviously, as Michael's touched on there. Investments, including enterprise management incentive options. Restructuring purposes, again, seeing a lot of valuations in this context, and not surprising, given sort of the pain the world's gone through in the last sort of nine months, and probably will continue to go through in the next few months. For M&A reasons, sale and purchase, management buyouts, and for IP valuations, intellectual property valuations. Now, in terms of sort of your instructing parties, I think the key point to note here is that many different parties may require a valuation for a number of different reasons. So we're seeing, be it solicitors, individuals, companies, anyone could require a valuation. So move on to the next slide. Yeah, I thought it'd be helpful to walk through some of the principles in evaluation. Now, SME businesses are generally sold based on a multiple of maintainable EBITDA, as it excludes non-cash costs such as depreciation, amortization, and can therefore be used as a proxy for operating cash flows. In many circumstances, the future maintainable EBITDA can be quite different to profit before tax, for example, or even EBITDA itself, because of the number of adjustments that are required to be made to derive the maintainable EBITDA. So in this example, obviously stripped out interest, depreciation, and amortization costs. They're quite often a one-off or non-reoccurring items that need to be adjusted for, relocation expenses, that type of thing. And market rate sort of director salaries need to be adjusted. Quite often you find in a company's accounts that the sort of directors, for tax reasons, do not necessarily pay themselves a market rate salary, and therefore that needs to be adjusted. Finally, it's also worth noting that whether you use sort of 2 or 3 year sort of historical data or accounts or forecasts in deriving your maintainable EBITDA, it very much depends on the circumstance of the business at that particular time. Quite often, I like to have sight of the forecasts and do place weight on these as ultimately the value in the business is the cash flows that it's going to derive in the future. Moving on to the next slide. Yeah, so once the maintainable EBITDA has been derived, one then applies a multiple to this. Now, you need to do your research in respect to multiples. I'm very keen to ensure the multiple is based on the companies in the same sector as the company I'm valuing. And there are numerous subscriptions and databases you can get this sort of information from. And that derives an enterprise value. But if one wants to calculate the equity value, which obviously constitutes the value of the company's shares and loans that the shareholders made available to the business, a number of adjustments are quite often required. For example, adding back surplus cash, so cash over and above what is often required sort of on the ordinary working capital of the business, and deducting things like bank loans and HP debt. This is on the basis that a sort of a willing buyer will usually buy a company on a sort of a no cash, no debt basis. As I said, apart from the minimum level of cash required to fund the company's working capital requirements. Moving on to the next slide. Yeah, so that sort of touched very briefly on the earnings approach. Now, there are a number of other different methodologies or valuation methodologies, and I've scheduled out 3 here. The first one is the discounted cash flow basis, which involves discounting sort of the future cash flows of the business back to sort of present value to account for the time value of money. Now, this is an excellent valuation technique if forecasts are readily available and can be relied upon. However, there are often issues, particularly with private companies, about understanding or deriving an appropriate discount rate. So there are pros and cons for the DCF approach with regards to SME or valuing SME businesses. The asset-based approach, this is very simply your net assets, so assets less liabilities. It's often used to derive a floor valuation for a business. Having said that, quite a lot of property companies which have significant assets on the balance sheet are often used or often valued based on the asset approach. And finally, the dividend yield. This is less frequently used and is only really applicable where regular dividends are issued. Finally, COVID. Yeah, now, as I'm sure many of you are aware, obviously COVID continues to impact on businesses across a range of industries all over the world, and the impact that's having on businesses in different sectors is obviously significant. For example, everyone understands that the retail and hospitality sector has been decimated, and a lot of restructurings are going on in this space, and I'm seeing a lot of valuations in this area. Conversely, things like home fitness and those type of industries have benefited massively from the pandemic, and I'm seeing owners of those businesses think about getting their businesses valued now, because they might consider that now is sort of the peak value they will get for their business if they were to consider selling it. But I think the key point to remember is that every business is unique, and whether a valuation is required for restructuring purposes or for a sale and purchase, it very much depends on how and the purpose of the valuation. I think that concludes my slides. Yeah, so I think we're over to the Q&A side of things now.
Thank you very much indeed to all of our presenters, to Paul, Michael, and Nat. I can see already in chat, we've got a question about sharing of the slides, and I'm going to make a presumption, unless I'm otherwise notified, that we will be able to share the slides. Would that be right? Can I come to Charlotte? If that would be okay? Yes. So we will share slides with delegates. If you'd like to turn your microphones off mute, feel free. We will come to anybody who either wants to put a hand up, or if you would prefer to put any questions into chat. Otherwise, I have been sent some questions privately, and we've got about another 5-7 minutes. Maybe we could push it to 10 for Q&A. So if anybody's got a question, very uniquely, I can see everybody on one screen. Please do feel free to raise a hand. Otherwise, I will start with the questions that I have. Right, I'm going to start then with the first question. This is for you, Nat, if I may ask you. What's the current position in relation to directors being liable for wrongful trading?
Well, obviously, wrongful trading is one of those main regulatory risks that I was talking about that directors are exposed to if they run a company when it's either insolvent or in danger of insolvency. As part of the emergency response to the first lockdown and COVID, the government suspended liability essentially. There's some questions, sort of technical legal questions as to how that suspension exactly works. But that suspension came to an end, I think, at the end of September. Certainly it's now expired. So we're back to the sort of status quo ante, the rules as they were before this emergency measure was introduced. But it's not completely undone, and anything you've done during that 6-month period is still covered by the benefits of this changed approach. We're now back to where we were, and the risks are the same. But obviously, anything you did during that 6 months, you get a bit of an easier ride. I have to say, wrongful trading isn't the only risk. So I really think that it wasn't really that great a measure, and it didn't make as much difference in reality as it might have seemed. So I can understand why it's not been extended.
Lovely, thank you very much. Could I come back to Paul now with a question, please?
Sure.
Paul, a question. When you perform your earnings-based valuations, how do you decide how many years to look back at the financials And how much emphasis do you place on the forecasts?
Yeah, so I touched on this briefly in the presentation. I think it very much depends on, so if you take sort of the current circumstances, if I was looking at an SME, for example, that the financial statements ended February 2020, and I didn't have any management information, so management accounts post this date, I would, and given that that's happened prior to COVID, I would look at historically, probably 3 years, and then because I haven't got any forecast or management information, in theory, incorporating the impact of COVID, I would probably adjust the multiple down to reflect the fact that the valuation of the business, subject to the sector, obviously, will be affected by COVID. That said, if I've got financial statements and management information right up to, say, October, the last 6 months, in theory, will be significantly affected by COVID. So I would potentially place less reliance on that, on the basis that sort of the impact of COVID going forward, again, it's very, very sector specific here, but this is generalizing, the impact of COVID going forward, hopefully will plateau and things will get back to sort of normal in 6 months, a year's time. And ultimately it'd be wrong to significantly decrease the value of the business now, when actually in 6 months' time, we'll be back to status quo, hopefully.
Thank you for that. I'm going to look back to our audience, our participants, if there are any hands up for any questions from you, just doing a check. Right, I've got another question then here. Michael, can I come to you, please? Regarding share transfers, what happens if the existing shareholders want to transfer shares to their family?
So normally as part of an investment, new articles of association, which is the company's constitutional document, will be entered into, and that will contain various provisions regarding the transfer of shares. And normally the starting point will be that there will be a restriction on the transfer of shares, and that the existing shareholders will have a right of first refusal. It's possible, as part of the negotiations with the investor, to create an exception to that principle and have shares passed to a certain class or groups of people, which may include family members of the existing individual shareholders. So effectively the transfer then can be made free of the restriction without first having to offer them to the existing shareholders, which obviously would include the investor.
Lovely. And Michael, I've got another question for you, if I may. Will the directors appointed by the investor expect to be paid?
Well, if there is an investor director appointed, then it's possible that the investor won't want to suffer the cost or bear the cost of the any fees surrounding or payable to the investor director. Obviously, it's going to be an experienced individual who is not going to give up their time, typically for nothing. So in many cases, the investor will look to the company to reimburse the investor for its cost. Overall, the investor, beyond its upfront payment in the investment, doesn't want to bear any ongoing costs beyond that. So it's likely that they would.
Okay, thank you so much. We have been living through extraordinary times. Everybody knows that. Every business has been affected. I think really the last question that we may have time for, again, I'm searching the audience just to make sure I'm not missing anything that you may have and appreciate. It may be a sensitive topic for some people, and you may want to reach out to our speakers individually. But coming back, if I may, to Paul, you did have a slide on it and touched on it, but are you finding valuations tricky and difficult during the current economic climate?
Yeah, in short. Yeah, as I said in sort of my answer to my last question, the devil's in the detail, depending on how much financial information you have and at what point in time you have that financial information. Now, even notwithstanding the date at which you have financial information too, a lot of so if you just take the earnings-based approach, a lot of the multiples that derived or extracted from the various databases that we have access to are obviously based up to a certain point. So comparable transactions say up to May, or it can be even earlier than that. Now, those transactions were undertaken in a different world to what we're in today. So again, an element of judgment needs to be made as to, okay, well, this is the pool of transactions I've got, which ones are most comparable, and then how do I have to adjust that multiple, for example, if at all, to apply it to my specific company here. So yeah, very challenging. And the same goes if you're going to use, let's say, a DCF approach. At what point were the forecasts prepared? Have they been flexed to take into account COVID? If not, do they need to be flexed? You know, there's a whole host of issues that are arising that I say make it challenging, make it more interesting, whichever way you want to cut it. It's yeah.
Keeping you busy, Paul.
Absolutely.
Right, everybody, thank you so much. We're very much nearing the end of our presentation today. I want to thank again Longmores Solicitors, AZETs, and all of you for participating. I've got a couple of announcements for your diary. There are a number of chamber events coming up that we'd like to draw your attention to. Next Friday, December the 4th, there's an EU transition event that the chamber are hosting. Please do have a look at that, or we can send you the link in our thank you notes that you'll receive today. The other one, it will be our last general networking event of 2020. Some people will say thank goodness for that, but at the same time, it is an opportunity to wish everyone best of the festive season. So if you're feeling inclined, we'd love to see you on December the 9th for Christmas networking online. They've proven to be really popular events. We allow people to break out into various meeting rooms, and you've all got the opportunity to introduce yourself, tell us a little bit about your business, and perhaps how we can help one another. So that's me, Mary Sykes from Hertfordshire Chamber of Commerce, thanking you all. It is the end of our session. Appreciate that some of you will want to link and carry on the conversation after today. We'll share the recording with you. Thank you so much, and have a good, safe afternoon.
Thank you.